Hi guys, so Emma and I did our presentation on chapter 6, the civil rights. So we're just going to get straight into it. So the first thing that we talked about is the black predicaments. So through constituting more than 12% of the population, African Americans until fairly recent could not in many parts of the country vote, attend interactive schools, ride in front seats of buses, or buy homes in white neighborhoods. Between 1882 and 1946, around 4,715 people, which is about three-fourths of them, were African Americans, and they were killed in the United States. In the summer of 1911, a black man was charged with murdering a white man in Kentucky. He was dragged by a mob to a local theater and was hung. In 1942, a national poll showed that only 30% of whites through the black and white children could attend the same school. The political position in which African Americans found themselves until the 1960s made it difficult for them to advance their interests through festival legislative strategies. Though some allies were created with white people, they were also scared to make a difference in a political system. So additional allies would have to be recruited, or the struggle would have to be shifted to a policy. By publicizing their grievances and organizing a civil rights movement that concentrated on dramatizing the denial to blacks of essential and widely accepted liberties. After this strategy was achieved, blacks had become enfranchised, and legal barriers to equal participation in political and economic affairs had been lowered. The politics of civil rights became more conventional. Okay, so now we're going to talk about the campaigns in the courts. So the 14th Amendment was both an opportunity and a problem for black activists. Adopted in 1868, it seemed to guarantee equal rights for all, stating no state shall make or enforce any laws which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the law. So a major decision that was determined the legal status of the 14th Amendment was Plessy versus Ferguson. In Louisiana, they had passed a law that required blacks and whites to occupy separate cars on railroad trains within the state. Plessy, who was 7/8 white and 1/8 black, he refused to obey this law. He appealed this conviction to the Supreme Court, stating that the law violated the 14th Amendment. In 1869, his claim was rejected by the Supreme Court. Okay, separate but equal. Separate but equal doctrine established in Plessy versus Ferguson that African Americans could constitutionally be kept in separate but equal facilities. The National Association for the Advancement of Colored People, which is the NAACP, was the main organization that waged that battle. Forming in 1909 by a group of whites and blacks in the aftermath of a race riot, to get the court to change their mind about the 14th Amendment, it would require the NAACP to bring before its case involving the strongest possible claims that a black had been unfairly treated. So there was, I think, 2 steps or 3 steps to this it's 3 steps. 3 steps to this process. So the first step was to persuade the court to declare unconstitutional laws creating government that were separate but obviously unequal. And then the second was to persuade it to declare unconstitutional laws supporting schools that were separate but unequal in not so obvious ways. And the third was to persuade it to rule that racially separate schools were inherently unequal and hence unconstitutional. So now we're going to talk about can separate schools be equal? So in 1938, the court held that Lloyd Gaines had to be admitted to an all-white school all-white law school in Missouri because no black law school of equal quality existed in that state. In Kansas, Linda Brown wanted to enroll in her neighborhood school but was unable to because she was black. The NAACP took her case to the federal district, but the judge said that the black school that Linda could attend was substantially equal and denied her access to the white school. And then this is where we get into Brown versus Board of Education. So on May 17th, 1954, the Supreme Court was speaking through an opinion written and delivered by Chief Justice Earl Warren. The Brown case involved a class action suit. That is, it implied not only to Linda Brown but to other similar situations. This meant that black children everywhere now had the right to attend formerly all-white schools. In 1955, Supreme Court decided that it would let local federal district courts oversee the end of segregation by giving them power to approve or disapprove of location desegregation plans. In 1956, over 100 Southern members of Congress signed a Southern Manifesto that commended the Browns' decision. So now we're going to talk a little bit more about this topic. So the court then said that segregating education is bad because it has a detrimental effect upon the colored children by generating a feeling of inferiority as to their status in the community. Since the court had not said that race was irrelevant or unseparated, schools could be either one that blacks and whites were free to attend if they choose, or one that blacks and whites in fact attend whether they wanted to or not. In 1992, a poll showed that 48% of whites in the Northeast and 53% of Southern whites felt that it was not the business of federal government to ensure that black and white children go to the same school. Okay, so now we're going to move on and talk about the campaign in progress. So new civil rights were wanted, but it was more difficult than people expected. In the 1950s, killing had lessened frequently. Black leaders had no desire to provoke more killings just to get sympathy for their cause. From 1955 to 1956, the best-known campaign occurred in Montgomery, Alabama. Martin Luther King led blacks to boycott the local bus system after Rosa Parks was arrested for refusing to surrender her seat on the bus to a white man. This is a demonstration of civil disobedience. So civil disobedience is opposing a law one considered unjust by peacefully disobeying it and accepting the resultant punishment. The rioting succeeded in getting civil rights on the national political agenda. 4 developments made it possible to break the deadlock. The first one was public opinion was changing. The second one was certain violent reactions by white segregationalists to black demonstrators. The third was President John F. Kennedy was assassinated in Dallas, Texas. And the fourth was the 1964 elections did not return Johnson to office with landslide victory. In 1960, less than 1/3 of voting age blacks in the South wanted to register to vote. As time went on, the numbers only went up. By 1971, there was more than half. By 1984, there was 2/3. And in 2001, over 9,000 blacks held elective office.